All right, let's dive into a really fascinating legal puzzle. One from way back when, but it has this surprising connection to our lives today, our digital lives. We're talking about the case of the unreadable letter. So here's the big question. How can a private letter, something meant for just one person's eyes, end up at the center of a huge public lawsuit? I mean, it sounds like a total contradiction, right? But the answer, well, it all comes down to a single critical misunderstanding. And we're going to find that answer in this really unusual court case out of India from all the way back in 1958. It's a great story, actually. It's about a landlord, a tenant, and a letter that, well, the person it was sent to couldn't even read it. Okay, so Section 1, a letter and a secret. And that's really what this is all about. The whole story hangs on this one private letter and a really important detail that one person just didn't know about the other. So let's meet the two people at the heart of this. We've got Harinandan Prasad, who's the tenant, and then there's Mahendra Ram, his landlord. Now, on the surface, just a typical landlord-tenant situation, but there was this one critical difference between them that really kicks this whole thing off, and it's this. Harinandan, the tenant, he couldn't read Urdu. All right, on to Section 2, the Urdu notice dispute. And yeah, that one single fact that the tenant couldn't read Urdu is what sets the stage for everything that comes next. So here's how it all played out. First, some kind of dispute pops up between the two guys. In response, the landlord, Mahendra, he drafts this formal registered notice. And let's just say it's got some pretty strong accusations in it. But here's the catch. It's written entirely in Urdu. So Harinandan gets the letter, but he can't make heads or tails of it. What do? Well, he goes and asks a neighbor to read it for him. And right there, in that moment, all this allegedly defamatory stuff gets read out loud, not just to the neighbor, but to a whole group of people who had gathered around to see what was going on. So you can imagine Harinandan felt like his reputation was just destroyed in front of everyone. So he sued his landlord, and he sued for 500 rupees in damages. Now, I know that probably doesn't sound like a lot of money to us today, but back then, that was a pretty significant amount. Okay, Section 3, the court's crucial question. Because, as you'd expect, this case worked its way up the legal ladder, all the way to the High Court. And the judges there had to boil it all down to one single crucial question. And here's what they had to figure out. By sending a letter in a language you know the other person can't read, which pretty much forces them to show it to someone else, did the landlord technically publish the nasty things written inside? Literally everything depended on how they defined that one little word, publication. Which brings us to Section 4, the verdict on publication. So, what did the court decide? How did they rule on this key issue? And get this, here's the twist. The High Court ruled that the landlord, Mahendra Ram, was not liable for defamation. The tenant lost. Which, of course, makes you go, wait, what? Why? Well, to get the court's logic, we have to understand what publication actually means in the world of defamation law. See, it's not about printing a newspaper or a book. It's much simpler. It just means communicating defamatory stuff to a third person. Anyone other than the person who wrote it and the person it's about. So for any defamation claim to actually work, you've got to check 3 boxes. 1, the statement has to be defamatory. 2, it has to be about the person who's suing. And 3, and this is the big one for our story, it has to be published. Now, in this case, the first 2 points were pretty straightforward. It all came down to number 3. The whole case really balanced on this one idea. The court said the tenant had to prove that the landlord either knew he couldn't read Urdu, or at the very least should have known. In other words, was it reasonably foreseeable that Harinandan would have no choice but to ask someone else to read the letter for him? So let's break that down because it's super important. The court basically said, look, it was Harinandan, the tenant, who actually took the letter to a third person. He's the one who started that communication. And here's the knockout blow. He couldn't prove that his landlord had any idea he couldn't read Urdu. There was just no evidence. So because of that, the court decided that having the letter read out loud wasn't a probable or foreseeable result of the landlord just sending it. Okay, so let's jump to Section 5, defamation in the digital age. You might be thinking, cool story from the 50s, but why should I care? Well, because the core idea here is incredibly relevant to how we all talk to each other right now, online. This old case gives us two really powerful legal takeaways that are just as important today. First, you have the publication test. It tells us that just because a third person sees a private message, that doesn't automatically mean the sender is in trouble. And second, the idea of foreseeability. This means the sender has to have a good reason to think their message would probably get shared.
Let's put this in today's terms. Think of that sealed Urdu letter from 1958. What is that today? It's basically an encrypted email or a DM. The law kind of assumes it's private, unless the sender should have known that it would have to be shared with someone else just to be understood.
Now let's flip that around and look at the opposite. What's the modern version of shouting something from a soapbox in the town square? That's your public social media feed, right? In both of those situations, the whole point is for a public audience to see it. The second you hit post, you've published it. Simple as that.
So if you take one thing away, let it be this. Foreseeability is everything. If you send a DM to one person, you're generally not on the hook for publication if they decide to screenshot and share it. But the moment you send a message to a group chat or post something publicly, boom, you've published it the second you hit send.
And all of this really leaves us with a tough question for our own lives, doesn't it? The law might draw a neat line based on what's foreseeable, but let's be real. In a world of screenshots and forwards, where anything can be shared in a second, is any message we send ever truly private? Definitely something to think about.